direito de marcas sempre impõe grandes desafios intelectuais. Seu objetivo é duplo e simétrico. Ele deve tanto proteger consumidores ao garantir que saibam exatamente o que estão adquirindo, sua origem e sua reputação, quanto deve assegurar aos produtores e comerciantes que, ao investirem nas especificações e na conformidade dos produtos que fabricam ou colocam à venda, não serão preteridos em favor dos falsificadores e easy riders. Para isso, as marcas devem poder ser facilmente distinguíveis pelos consumidores. Dessa necessidade, emergem dúvidas que devem ser apreciadas cuidadosamente pelo saber jurídico. O que é indistinguível hoje pode tornar-se suficientemente distinto amanhã e vice-versa. Mercados que não se tocavam no passado podem se mesclar nos dias de hoje em virtude do encurtamento das distâncias ou de mudanças tecnológicas e comportamentais. Na economia superintegrada da internet e da globalização, práticas de um país influenciam os demais. Quais são as melhores práticas? Marcas de reserva, marcas sem objeto definido, licenciáveis para quaisquer classes de produtos, marcas não convencionais, são muitas as questões e no Brasil precisamos nos apressar para não nos distanciarmos dos entendimentos vigentes nos princípios.
Thank you so much for your kind introduction. I'd like to thank ABPI for the invitation. I'd like to start by saying that this panel, given the topic, could mean a full Congress, controversial issues, and the examination and trademark decisions. Among controversial issues, we have precedents rights, which is going to be dealt with federal basis, coexistence agreements, parasite use, secondary meaning, combination of colors applied to packaging. So as I said, we have a vast range of topics to be dealt with. To participate in this panel, as we all know, we have Judge Marcia Maria Nunes de Bairro, federal judge of the 13th Federal Court, Federal Vision Trademarks Board, direct assistant to Laboussier, and our friend Enrique Diaz from Mexico, a vice president of ABPI. As I have taken a peek at the introductions of the presentations, I will give the floor to Judge Marcia. She's going to speak about secondary meaning. Then Alvezi, the right of precedence, and relevant cases in Mexico by Mr. Diaz. Of all the cases, the 3 cases he's picked, each one has a different relationship to the Brazilian legislation and judiciary. Judge Marcia, you go ahead, you have the floor. Ricardo, thank you so much. Before I start, I can hear something. I'm not sure. Somebody has their mic on or YouTube is on. We hear something in the background. So I'd like to start my presentation by thanking Ricardo, as well as President of ABPI Monterrey, as well as Erica in her kind introduction, has given a full view of my presentation. I intend this morning. Obviously, we won't have time to speak about everything we'd like, as Ricardo said in his introduction. But I'd like to say about two things: social changes that impact registration of a trademark and distinctiveness changes of a trademark. For changes in distinctiveness of a trademark, talk about or degeneration or vulgarization, and as well as secondary meaning. I'll start by saying that we know that trademarks have a legal role, an economic role, a social role, protection, consumer protection. But trademarks also have other important aspects. Semiological aspect. I brought a quote from the United States. Protection of trademarks is the recognition of the right of the psychological functions of symbols. We appropriate ourselves of symbols, and through those symbols, we become loyal. We pick trademarks. We're loyal to them, and sometimes because we don't like a product, we don't want to buy that brand. So this happens in the trademark world. Brands are can become very famous. They can be considered to be well-known trademarks. We have a number of examples of brands and trademarks that were extremely famous, but because of technology revolution, because of bad management, because of problems in the economy, used to be well known in the past. They're unforgettable, and as at least those who are older here, maybe the younger people don't remember these trademarks, but people say time flies. And Bamerindo's Bank had a motto that the other day I said that in a group of young people, and they had no idea what I was talking about. But these trademarks may stay on for decades, but today these trademarks you see on the screen, they don't have much impact in the market. Grappete is back, but all the other ones don't have any commercial value today. Now moving on to vulgarization. The main feature of a trademark, obviously you have to have other requirements, but the main requirement is the distinctiveness of a trademark. A sign to become a trademark, it has to be distinctive. So what happens when there's when there is vulgarization? So there is excessive distinctiveness. So the brand pops out of the product it designates. It is kind of an overflowing of this distinctiveness. So the brand and the product become kind of one thing. One talk about the pathology of fame. It's fame, but to an extent that it ends up not being positive. There are a number of examples here in Brazil of this case. These are examples. I'm not saying that they're not worth anything. Actually, the opposite. All these trademarks registrations are still effective, but we know that for all of these products, these products have become, these brands have become the products. Q-tips in Brazil, they're called cotonetes. So these Q-tips are cotonetes in Brazil. People don't know the difference. If you say, there's another one, Pyrex, it stands, or Xerox. Xerox, you have an ad, a small ad, a colored Xerox, it's a Xerox copy. So people use the Xerox. Nobody's saying photocopies, black and white or colored. People say colored Xerox in Brazil. The problem is that I checked them all out. So they're already in the dictionary. They have become entries in dictionaries. In dictionaries, these are trademarks that have become a product, that have become the product. It would be great that everybody knew a product given the name of Pyrex. It's for the right holder of that product. It's very difficult. Here's the only case I found in the Superior Court of Justice. Insufilm is a product. And there was a competitor that were using the word Insufilm to announce its product. And then they ended up winning the case. But if you look up on the internet, if you place Insufilm on Google, you see hundreds of companies offering Insufilm. This is a film for darkening car windows. So if the company does manage to make the distinction between the product and the trademark itself, at the end of the day, this vulgarization process is impossible to control. The other side of the coin, when it comes to secondary meaning, you have a sign that originally that it was not distinctive, and then it becomes a distinct trademark, or a sign that was weak in distinctivity, but this starts to gain force with time, and the people start to recognize it, and then it becomes stronger, and then it increases its protection aspect, because the trademark, the weaker the trademark, the less it can defend itself from similar trademarks. This is a basic principle. The more the higher the distinctiveness, the stronger the trademark. Here, I'd like to mention under secondary meaning, we have claims in the justice system. Very often, in most cases, people claim secondary meaning, but they don't bring any evidence. So here I have an opinion. It is the burden of the holder to bring the evidence. The burden of proof is up to the holder. You can't just claim it. It's not just a personal impression from an expert or a judge. There has to be a production of evidence from the consumer. saying that meaning has been appropriated by consumers as belonging to that trademark. We have very high-profile cases. The Granado powder. The trademark was registered, but you have other cases. Boutique dos Relógios is a watch boutique, watch store. Also here, the decision saying it has to be grounded on evidence, demonstrating the projection of this new secondary meaning in the market. This has to be part of the complaint, the petition. This case is Arno Turbosilence. Arno, fan manufacturer, wanted this to be a secondary meaning. This was not proven. This was actually the opposite. Turbosilence was registered because of Arno, because for fans, it's just a description. This case in the higher court is very interesting because this is a case from 2019, recognition of secondary meaning as the name brand American Air. I'm sorry. My slides are out of control. I'm sorry. American Airlines. The American Airlines is an aircraft. It's a airline company. But American Airlines cannot obtain nullity of America air taxi that carries passengers by air, but it's a different type of transport, so there's no confusion. It says that there can be secondary meaning when it's suggestive. You still have to have the trademark living with other trademarks in the market. Maybe a different case would be if these trademarks emerged after the secondary meaning had been recognized. Here it is. The exclusive use is not a logic consequence of recognition of second meaning. Another opinion by Justice Salomon. I thought I would have loved to have worked with this law case. I thought that the opinion from the higher court extremely adequate. It's perfect. Talking about the various degrees of distinctiveness, those that evoke certain things, and also mentioning case law. When the trademark evokes certain things, distinctiveness becomes weaker. When Gradienti produced an iPhone, it was a whole line of products. It was during the coming of the internet, iPhone, iTV, iRadio, a number of, then they also made Gradienti iPhone. Two elements, one main element, which is gradiente, and two secondary ones, the G and the iPhone. And then the iPhone is a term that evokes, and therefore it has to live with, they have to live with the trademarks, and it has to live with other trademarks. However, the higher court says that after Gradiente iPhone, Apple managed to increase distinctiveness of the iPhone. Actually, getting secondary meaning. And then from that moment on, other companies would not be able to use the iPhone. So this decision was extremely interesting. I think this brings grounds to apply enforcing secondary meaning theory in Brazil. I'm not sure how much time I have. 5 minutes? Ricardo, if you let me know if I run out of time. On the other hand, and other attempts to organize this panel, Enrique mentioned the cases he was going to present, and then I remembered a case of a research about trademarks. We call them immoral. They are not registered as trademarks based on Article 124 of the Intellectual Property Act. I just wanted to get food for thought. What are these signs that cannot be registered? Because it's very difficult to enforce this. First of all, the definition of moral and good practices, often this is personal, sometimes this is regional, sometimes it's a time-related thing. So, people judging, they have their own political convictions, geographic and cultural elements, and also the issue of social evolution. So as society is constantly evolving, sometimes it looks like we're moving backwards, but this makes it difficult to enforce the immoral trademark principle. The USPTO advocates that, among other approaches, you have to see the target of the brand. There was an article of 2 examiners of the Brazilian PTO, very interesting, about the immoral trademarks. I read these articles, and some of my examples I took from there, talking about target groups, target audience. Would that be enough? If we look, for example, this is an American trademark, MILF. Mom's intent on looking fabulous. This is a cosmetic company. Anybody with reasonable knowledge knows that MILF is a very different acronym. Mothers would like to fuck. I apologize for using the F word. But this MILF was accepted by the USPTO. So, because it says it was a different meaning, but the mothers that are going to buy the camisa, if they know the other meaning of MILF, they are going to be using the product and people are going to see them and then wearing the cosmetics, and they will judge that they are going to that they have some kind of hidden agenda beyond just using the cosmetics. This is a condom brand. The claimant was given grounds. They were looking into making a statement. So the trademark registration was granted. This is not cosmetics. This is a bar and restaurant service. This is great. This is the excuse because the claimant alleged that the Dick's heads, it was just a nickname for Richard's heads. But the examiners thought that was it was similar to anatomic vulgarity, and it was not granted. Marcia, I'm sorry, I had a problem with the sound here. Just give you 5 minutes. Yeah, I'm just about to wrap up. Illegal substances. Here is the Brazilian case. The Brazilian PTO usually denies these applications regardless of the services and products. Exception of the Planet Hemp trademark. It's a music band. After appeal, they granted because this is freedom of expression, it's an artistic movement, and so on. And here, the last case I dealt with recently, you have this leaf here. It's just an illustration because they were named trademarks, Brazilian marijuana and Brazilian cannabis. And everybody knows that this is related to pot. And it was denied based on 125.43, and the person appealed. And then I did not use the argument of 124.3 because today pot for medicinal use is not banned. Pot has been imported legally. Also, the higher courts, have decriminalized for certain uses. So I understand that at this point in time, you can't deny this registration given the moral and good customs. But it was denied because it was described with 124.6. But the Brazilian PTO had granted a number of other registrations for cannabis and other things under Article 124.6 and not 124.3, both for this holder and for other holders, based on 124.6. But in the specific case, these were two denials under 124.3. And then just to wrap up, when we talk about illegal activity, these trademarks applications were all denied. Ideology, never granted by the Brazilian PTO. Nudity, there is a standard mentioning the buttocks or genitalia, even if they are image elements. I had to search what they were. Most of them were clothing. And just to wrap up,
the atmosphere, how these decisions are permeated by a male-oriented perception, because these trademarks that were not so explicit, because there is a name, they are refuted. And we have famous beers, for example, that are called, for example, in Portuguese, devassa, which is popular in the market, and nobody sees any problem with that. So I apologize for going beyond my time. Thank you so much, and I'm ready to answer your questions later on. Thank you so much, Marcia. This topic certainly would allow us to hold a few seminar, and you're able to summarize in half an hour a brilliant presentation. Thank you. Many comments certainly would arise. You, I remember a reference, you made certain names such as Vitrola, Macacão, and GP, such as the the cotton stubs. And there's also a reference to traditional examples, as you mentioned, American Airlines, another U.S. company, American company. They can also claim to be an American. If it's an airlines from the United States, they can say American Airlines. Or, for example, any Brazilian bank can claim to be a Bank of Brazil. So these are classical examples. They're good because they are easy to be remembered. They are very clear. So brilliant presentation. Thank you once again. I knew it was going to be good, but certainly it went beyond my expectations. Thank you. I'm sure we are all not talking about it. Pedro, your turn. You have the floor. And I'd like to ask you, please, to keep to the 20-minute presentation that we were, that has been established. You're also going to talk about a very exciting topic. Okay. It is certainly a temptation to bring to the discussion some of the topics pointed out by Dr. Marcia. And let me first greet all of you. And I was asked to speak a bit louder. Can you hear me now? So let me greet all of you, and in particular, our director, Malucia, who was unable to come, but who is certainly seeing us on the screen, and I was given the responsibility of being here to talk on behalf of the directors. So on behalf of all my colleagues from the Brazilian PTO, I'm very glad to be here. I would like to thank for this opportunity to be here. And first, let me start with an introduction, going back to something that was said during the plenary session when the decision-making standardization was being discussed. And then we go specifically to the right of a precedence, to the right of priority. But first, a caveat. I would like to highlight the importance that the trademark directors give today to such issues. And I would like here to establish an analogy. There is a movement of specialization in our courts in certain areas which are specializing in industrial property. So in terms of trademarks, there is a similar trend in terms of allocating specialized employees for such cases. Such as 2017, we've created a coordination which is called ODIR. It's a special unit coordinated by Dr. Balussier, and I was part of this coordination, this unit for 2 years. And among other attributions, they have a special task. employees who are trained and specialized to take care of such cases together with the due agencies that participate in terms of such administrative acts and registration. But every time the prosecution or any other agency will be asked to reach a decision, we have a very qualified team that has this basic attribution. They will not be in charge of examining trademarks. They have to draft the technical instruction and guidelines, which is very interesting because it allows us to follow up very closely on all cases, and it reflects a view of our directors in terms of the importance of court decisions, especially the decisions from the second region court vis-a-vis trademarks and of course geographical indications and industrial design, because the Brazilian PTO sees that as a very important source, is a very important opportunity for us to manifest and to present to judges our perception, our understanding on certain issues. The aim is to contribute, as always is. The aim is to contribute so that we can reach the best possible legal decision, judicial decision for each concrete case. At times, we know that our directors do not hesitate in taking a stand in a certain situation and before the court. So we are very clear in our position. But for us, the court decisions are very important, not only for the development of our technical decisions, but also for our own understanding. So having said that, I would like to turn to the priority right. I think undeniably, this is a controversial issue. And I say that because throughout time, we've seen different positions being adopted in terms of the priority right. This was mentioned by Judge Abel Gomes as one of the issues when he was talking about standardizing decision making. I think it's also very relevant because it has an impact. Well, let me explain it. What we have when we have this system has implications in the very logic of our system of trademark protection, because our system is based on attribution. But the more we interpret, the more we give room to the previous use of the trademark as a decisive criterion to assign property, the better are the results. And in certain countries, the system is different. Registration is a declaration, is a recognition of a de facto reality, which is not the case in Brazil. I think in Brazil we have a mixed system. So let me go to my first slide. What do we have here? The right of precedence, which means the right of the previous user. In our system, we have these 2 points, attribution and anteriority. And here we are talking about the right to have protection or to have exclusive use when a registration is made. And the principle of anteriority is, of course, the first to file, which has this right of prevalence. So these are the 2 main basic assumptions of our protection system. Our system is not an absolute one, as I said. There are exceptions to our prevailing system, which is based on attribution. So the first consideration is that a non-registered trademark can be protected by means of Article 126 or by means of the unfair competition. So, of course, this protection exists, but it's also clear that registration confers a higher degree of protection. Within that, we have another aspect, which is the right of precedence. And that means giving the previous user right to register. This is the sole paragraph in Article 129. Actually, let me go back to the previous slide, or go to this one very briefly. Let me read the article. The holder of the mark, the holder of the trademark, talks about the sub-attribution. And now we go back to Article 129. Any person that in good faith in the date of filing used in the country for 6 months has an identical or a similar trademark will have the right of priority over this registration. What does that mean? In terms of this current situation, there's precedence when you have already used or requested the trademark. If you go to the Brazilian PTO and there is already another user applying this trademark, that's what's going to govern. So the requirements are very clear. We talk about good faith, our user in good faith, that's the text of the law. And we see that both in terms of the administrative, just as legal, a good faith user is deemed to be someone who has not tried to register before the filing by this person who has having his right denied. So this brings about an exclusion in terms of a good faith user. It is as if different things were being tried in different ways. But the idea is that the finality of this provision is to give opportunity, considering the size of the country, the multiplicity of agents. So it's to give opportunity to someone who is using the trademark but had not yet registered at the PTO to have this precedence. So if the user already has a registration and it has elapsed, or payment has not been made, or had not asked for a continuation, so this individual will lose the right of precedence. Second point, the previous use of the trademark for at least 6 months prior to the filing done by a third party in Brazil. So this is the second point. And also, it has to be a similar or identical trademark for a similar or identical service. So the right of precedence can be used in terms of one trademark for a certain product if there is a similarity or if they are the same. So the major issue at stake does not concern the requirements, but rather concerns the enforcement, the application. When we read the law, I have the feeling that it's not very clear. All user in good faith will have the right of precedence to the registration. But what registration are we talking about? Are we talking about absolute priority? Are we talking about the right to be prior to a registration, to a trademark that has already been registered. So I think there are some points in the drafting of the law that has give rises to these disputes. Of course, there is an initial point of reference, which is a third party goes to the Brazilian PTO, and there is already a and there is a trademark, but this trademark has not been registered. So what is the time frame for that? How long before his right of precedence elapses? And of course, you can use an opposition instrument before the trademark is granted. But can someone ban a registration that has already been given? Could that take place? So basically, we have two different perspectives. The first one is that in questioning the right of precedence, and this is something that should be done after the filing, but before the granting, before the concession, because we are talking about good faith. We are talking about of someone who was diligent, maybe was already using or not that trademark, but that would give right to the privilege for the good faith user. And there's also the right of a preceding, of coming before that registration is granted to a third party. And the only way to do that is through administrative opposition. Once you grant a trademark, the registration of a trademark, there's no longer a possibility of having this right. This is the current position adopted by the Brazilian PTO. The consequence would be declaring that registration null, but rather an inversion, because there are two assumptions. Someone has someone has filed before, and then there's a second action. So instead of applying the principle of anteriority, you reverse the order and you approach first the one that has the right of precedence, as long as this right is well grounded. So this is a restrictive perspective, which is the prevailing position at the Brazilian PTO. So if the first time this is questioned, the first time it's brought to the Brazilian PTO without a previous presentation of an opposition, this is today, according to our approach, we are talking about an exception to the rule of attribution and anteriority. And we also have to consider legal security and provide grounds for this logic. We have to preserve the good faith filer. And this is also the position of the federal prosecution together with our agency, the Brazilian PTO. The second region, until 2017, has upheld this position. So for a long time, there was a convergence between our understanding at the Brazilian PTO and the judiciary. However, towards the end of 2016, the STJ has changed its position. This was a decision of Judge Andrighi. And according to this decision, there would be no need for a nullification action by means of administration opposition. And this decision was upheld later on based on 2 points. First, that the legislation, when it deals with the right of preference, is not clear in terms of the time frame in which it should be presented. And because the law is not covering it, we cannot limit the right of the citizenship once the legislation does not expressly say that it's only before the granting of the registration that the right of prevalence will be effective. So if the law does not spell that out, it's not up to the judiciary or to the Brazilian PTO to decide it. And there are other aspects to it. So it's possible that this case is considered in court in spite of the fact that it has not been considered administratively. So this 2017 decision has brought a different perspective, and I think there is a need for further discussions. The Brazilian PTO is always open to reconsiderations and reassessment, and I think we should really further discuss that. Could we reach an intermediary position, a middle ground position in which we would contemplate the good faith user, which could benefit from the rule of anteriority without neglecting the pre-user of good faith, in good faith? So I want to highlight that last year, Dr. Marcelo talked about this topic in his presentation during the Congress, and he mentioned a possible middle ground understanding which would consider the possibility of having the post-nullity be done depending on this time frame of the concession. So this is just a seed for thought. I'm proposing this middle ground position for your consideration and for further discussions. And I would like to highlight the position of the Brazilian PTO is that it should be done administratively in terms of the opposition, but we always have an eye to what is going on in the judiciary, and we are ready to contribute with our studies and our understanding and our experience. Thank you so much. And if we have later on an opportunity to discuss some of the issues that Dr. Marcia brought about, we are ready and willing to do so. Yes, I'm also looking at the questions that are coming in. Excellent, your presentation. I'm already getting compliments for your presentation. In fact, I think there are three positions there in terms of the opposition after the granting and the middle ground, which is once elapsed that time frame for opposition, there is still time because the granting, the final granting has not been given. So this is an excellent topic to be debated, especially when we have three distinct positions. Thank you so much, Pedro. I knew your presentation was going to be excellent. And I'm telling you, I'm getting very positive comments on both presentations this morning. So I'd like to give the floor now to Mr. Enrique Diaz, who is going to tell us about some relevant cases that took place in Mexico. And I'm going to say a few words afterwards because I've already seen his presentation. These are three very interesting cases and three different applications vis-a-vis our legislation. Enrique, you have the floor.
Thank you very much, Ricardo. First of all, I want to thank ABPI for the kind invitation. In my name, and of course in the name of our president, Ms. Elizabeth Simpson, has always been a pleasure to collaborate with ABPI. So it is a privilege to be with you and sharing this panel with Pedro and with Marcia with completely three different points of view. First, we have the administrative standpoint from Pedro, and the judicial standpoint from Marcia. So it's great to share these different topics. And of course, I want to thank Marcia, because I knew the acronym MILF, but I did not the meaning. So I'm learning something at the beginning, is general culture. So the 3 points that we are talking about, and the next, please, and the cases I'm going to present to you have to be with, first of all, you have one case in which is a general case in which the trademark was granted, representing a company called Hyundai. They applied for a trademark, Hyundai Tucson. Tucson is a car that is worldwide known. And the Mexican Patent and Trademark Office cited as a bar the trademark Tucson. So basically, the bases were very simple. The plaintiff filed a cancellation action on grounds of lack of use against the Tucson trademark. The defendant did not file an answer. And at the end, the trademark Tucson was canceled, and the Hyundai Tucson trademark was registered. So that would be very, very, very simple. The interesting part about this situation is that the Mexican Patent and Trademark Office did all the process. They granted the trademark, they filed, and they completed the action, the administrative action of the cancellation. And at the end, it was completely, sorry, I'm trying to move here. Next, please. Yes. So what happened here is that the Mexican patent, even that they followed the proceeding, the defendant went to the court and they filed a complaint claiming that the MPTO did not serve correctly the administrative proceeding for canceling the trademark on grounds of lack of use. What happened is at the end that they claimed this, the Hyundai Tucson trademark had already been registered. By means of the Mexican law, the only way to cancel a trademark is by starting a cancellation proceeding. So what happened here is that the Federal District Court ordered a decision to restore the cancellation proceeding on grounds of lack of use. But additionally, they ordered to the MPTO to cancel the Hyundai Tucson trademark without a normal proceeding and without any proceeding. So this is an unusual situation. I know that I have discussed this case with Marcia and with Pedro, and in Brazil would be similar. The court could order the cancellation of a trademark in order to restore proceeding. However, in the case of Mexico, is one of the fewest precedents that we have found in which the court ordered to cancel a trademark without the proceeding and without a general proceeding. So next, please. The second case I'm going to present has to be with the trademark Pinche Gringo. It's very similar to many of the cases that Marcia presented. It had to do with MILF, with Old Glory, with Brazilian marijuana, and ADM. Let me explain you, first of all, what's Pinche. Pinche could be a word that is considered slang. So it could be considered a despicable word. It could be considered a bad word. But at the end, by itself, it is not a bad word. So it becomes despicable when you use it as a slang in a negative way. So by itself, it's not a bad word. So what happened here is when these persons apply for Pinche Gringo Barbecue, obviously for restaurants, the Mexican Patent and Trademark Office decided to deny the registration because it was against the moral, the ethic, and the good customs. So when the decision was issued, the owners of the application, the applicants, decided to file an appeal at the Federal Court of Administrative Affairs, which at the end was confirmed. So the last instance here was the Court of Appeals. So they decided to apply file an appeal, and the court decided to revert the decision. It's very, very interesting here because when I hear the position of Pedro, when I see the interpretation of Marcia, and at the end, it's very common that in all our countries, in Latin American countries, many trademarks are denied because they are against the moral, the ethic, or they have a negative meaning. And most of the cases, the courts are the ones that are reverting or issuing these kind of decisions. At the end, the Federal Court of Appeal decided to grant the trademark, and the interpretation was exactly the one that I'm talking about, because they say that the word pinche itself, without being associated, next please, without being associated to another word, which in this case was gringo, which gringo was a way in which the Mexicans refer to the persons born in the United States. Gringo itself doesn't mean anything. However, when it's said from one side to the border to another side of the border, it's considered that it has a negative meaning, or really that you are being despicable or aggressive to the other citizen. Next, please. And the last case that I want to talk about, next, please, it's a very interesting case because it has its background. It's a case that took place in Mexico for about 10 years, and it has to do with damages. Damages has been one of the worst and most difficult situations in Mexico, because at the end, you have an owner, you have a trademark, you have an infringer, but at the end, nothing happens. It's very difficult to collect damages in our system. And I'm going to explain you after this case why this situation continues and will even get worse. What happened here is that a very well-known company in Mexico starts selling a product without the corresponding registrations, or in certain classes, for a trademark called bondage. Bondage was very, very famous probably about 15 years ago, 10 years ago, and then it became diluted and stopped its use worldwide, or continue, but in very, very, very few sectors. So what happened here is that a person that had a registration for Dutch in a northern state, it had a federal registration, of course, but it had a trademark for Dutch, saw this situation and it decided to start registering trademarks Dutch around and file lawsuits for infringement against these companies. Next, please. What happened is that most of the infringements were confirmed, and the Mexican Patent and Trademark Office decided and imposed a sanction to the owner to do the illegal or the incorrect use of the trademark bondage. However, this is not the interesting part. The interesting part is that this person decided to go to a civil court and claim damages. In Mexico, in the current law, we have not punitive damages, but we have a persistence of a claim for damages. What it says basically, when you can't prove the direct damages, you can obtain at least 40% of the public selling price of the infringing products. So that's something that is in the law, but that is something that the courts have never been able to confirm. And the situation is very simple. After all the steps, they filed the damages claim at the Court of Common Jurisdiction, who denied the payment of damages. They appealed the decision, they denied it. They finally appealed at this court, they denied it, and the case was attracted by the Supreme Court in Mexico. And at the end, next please, basically what happened is the court decided that the infringement was not a direct, the payment of damages, was not a direct consequence of infringing a trademark. So since we are a civil country, you still need to prove that there was a direct, that there was damages, and that really, because of the use of the bondage trademark, the owner of the Dutch registration had a loss of profit. Since they were not able to prove the loss of profit, the Supreme Court decided to deny the payment of damages. So Sears was completely exonerated. What is interesting here is this proceeding took a long time, 10 years. Most of the cases in Mexico, they get settled, so it's hard to get a final decision. But what happened now in our system is very, very weird and unique. In Mexico, we have, I would say personally, that we have the most powerful patent and trademark office in the world because they grant rights, they cancel rights. But now, starting on November 5, we have this hybrid legislation that will come into place that is very unique in terms of damages. Basically, what happens is that the new law establishes that the way to claim damages may be go directly at the court of common jurisdiction, but now it states that the damages may be imposed by the Mexican Patent and Trademark Office. In my opinion, that is not just weird, but completely unconstitutional. So probably if I get the chance to be invited to another presentation next year or the year after, we're going to have many decisions in which the courts are going to be ruling if this provision that was included in the law is correct or is completely incorrect or is completely unconstitutional. I don't believe that the Mexican Patent and Trademark Office should be allowed to grant, reject, cancel, and now to impose not just the fines, but additionally to determine the damages without following the theory or the civil theory of how to calculate the damages and how to do it. But at the end, is in some cases, our system is similar to Brazil. In some cases, it's not similar to Brazil. But for me, the most important situation that should be protected, and at the end, from a private standpoint, is that trademark should be protected and the owner of a trademark should be able to get restored or compensated when somebody infringes its rights. We are, as Pedro said, we are similar to Brazil. We are a mixed system. We are basically registration orientated, but we have many rights based on use. We don't have like this exception of 6 months that Pedro talked about, which is similar to priority rights on the Paris Convention, but instead of basing these rights in foreign applications, they're based on use. We can base it on earlier use, and there is no limitation for that. You can have either a coexistence, or you can have, if you are still on time, the chance to cancel the registration based on your prior rights, which were the use. So these are the 3 cases that I consider could be of your interest, basically because of the background and the way that they impact our system. We don't have specialized IP court. We just have a specialized IP chamber and the Federal Court of Administrative Affairs, but the rest is completely very diverse. We have all the sectors, we have the district courts, we have the Federal Court of Appeals, and that's how we have been getting our precedents. And we are going to be very active after November 5. We have a better system, but there are many weird things that were included in our report. So probably I'm going to share it with Marcia later, so we can have a retroalimentation of what she thinks about it. So from my side, it's all. Thank you very much for the invitation. And I would like to return the microphone to Ricardo to open the floor for questions to anybody.
I will start by saying, if you have any questions and you want to answer in Spanish, there is no problem. As to your presentation of the 3 cases, they're different from us. On the first one, you can actually file a nullity action without having the administrative procedure. The second, Marcia mentioned quite rightly, depends on the meaning, depends on the context. And then the third one goes all the way to the judiciary system. A Brazilian PTO doesn't deal with damages. Before I move on to the audience, I'd like to know if you have any comments or any questions about the presentation so far. Pedro, Marcia, and Enrique. In fact, it's just something maybe I didn't understand well, because I had to interrupt for something. In Mexico, even the same judge judging the validity of a trademark or judging the damages? Same judge judging the damages?
It's a different judge. You have to go. Currently in our system, you in order to be able to claim damages, you need to get a final decision from the Mexican Patent and Trademark Office declaring the infringement. Once you have a final decision, that document is going to be used as the legal standing to start a civil proceeding to collect damages. And you go to a court of common jurisdiction at the first instance, which may be later appeal, and the final decision is taken by the Federal Court of Appeals. What happened here is that this case was attracted by the Supreme Court, which is not very common that the IP cases get attracted by the Supreme Court. And the magistrates are the ones that decided that there was, in spite that there was an infringement, there was no right to be compensated with damages.
Pedro, so the violation is then dealt with at the administrative level. Is that right?
It is correct.
I just wanted to make a comment about item 3 on her presentation, on Marcia's presentation. I think it was very interesting. I am opening the manual for trademarks right here. I think this is a very important repository. I recommend it for information, both for the users, but also as a reference for public civil servants as well as examiners and users. I am not going to be long about this, but the management of knowledge in the trademark area is very important. With practically full resolution of backlog, we can really turn our attention to quality. So under this coordination I had mentioned, dealing with legal action. So you need to have a knowledge management based on the trademark manual and procedures for reviewing this manual, suggestions that are quite good, and bringing the manual. I'd like to give you some examples. There are guidelines, general guidelines in the manual, and some examples that should not be used as written in stone, but they serve as a reference, as a benchmark, so as to Marcia mentioned. For example, for moral and good customs, if you register somebody asking to register Ku Klux Klan, KKK, for any product, it is so universally well known, KKK, that the trend would be to deny this to any type of product or service, or the swastika, the Nazi symbol, or expressions that are known, universally recognized. I think these few ones, they, regardless of the product or something, they'd be denied. But then there's another example of a denial that would depend on the product. I'm talking about this theoretically. These are examples from the manual, but that also have to do with what Marcia said. Well, for example, the damn, or for example, let's say like a toy for children, a damn toy, that would be denied, because when you analyze it, it wouldn't be right. But let's say it's a sex shop, and it's kind of like, let's say instead of saying damn toy would be like a hot toy, then it would be evocative. So there is a small number of products and services that have a reputation, a universal reputation that would be denied in any case, obviously with a certain degree of subjectivity. But when examining, you need to gather the most amount of evidence possible And the majority would have to be an assessment that depend on the product or service that the trademark is attached to. It's just to say that I wrapped up. This is it. This is my comment. Then the first question, Ricardo, excuse me, if you allow me. The problem that we're faced with at this time, there are people wearing KKK hats right outside the Supreme Court. We have a big problem here. That's right. So we're going to be able to register the KKK hat in the Brazilian PTO? Well, don't look at me. Well, you are the BRPTO. Well, given the example from the manual, I think this is universally known. It goes way beyond. Now, I'm just joking. This is a teaser, just to say that the Brazilian PTO manuals and guidelines are critical for everyone working with this area. One needs to get to know these manuals and guidelines because in general terms, pretty safe parameters for those working in this area. And I'm happy to hear that you're working on integrating court decisions in the manuals. I've always criticized that in other countries, in Europe, in the United States. Usually guidelines are formulated on what the justice system has produced, and this is not something that we don't see here. Guidelines don't take court decisions into account. So I'm very happy to hear that. Congratulations to you and your team for developing this effort. Really critical effort. I spoke to Enrique some time ago when we were creating this panel, as he mentioned. The new law enacted is coming into effect on the 5th of November, already incorporating some controversial issues, including it in the law. So this helps. This makes life easier, actually. So the first question I have here, Pedro, is addressed to the Brazilian PTO, and you as an address assistant, technical, as of right of precedence, if two or more companies apply simultaneously the precedence right, the first one who submitted the petition or the one using the oldest, showing the oldest use? Well, yeah, I know what you're going to answer is in the manual. Yeah, perfect. I forgot to put this on my presentation. This is really important. We have a very well-defined criterion on this. I was faced with a case. If I recommend people should read it, go ahead and read it. Regardless of the old use, whoever petitions first is going to have it. Just to remind you that the trademark manual is available on the Brazilian PTO website. There are a number of interesting information and guidelines. Both the claimant and the defendant, the criterion is for the one that has petition first, that filed first for registration. It doesn't matter how long they've been using. For the Brazilian PTO, it is going to be the one filing first. If both prove prior use, and that is also the case for corporate names. Yeah, those that have claimed for the right to register. So they have an opposition, and then if the applicant proves they were using the prior use, then the prevalence is going to be of that person that proved that it started to use at least 6 months before the application.
There's a second question from Dr. Machado to Enrique. How is this issue of the right of preference treated in Mexico?
Well, it's similar. Well, it has some changes, but at the end, we have basically our system is registration orientated. We do not declare the rights. We constitute the rights by the means of the registration. And the earlier user, by the way, if you have a registration and you start an infringement against a person that had an earlier use, they can defend the infringement just by stating and proving the earlier use. But additionally, if they're still on time, they could file a counterclaim claiming the cancellation of the trademark based on the earlier use. So it's similar to Brazil. We have a mixed system. What gives you the strongest position, of course, is the registration, because it may shield the owner against an infringement. But additionally, the user by itself may be protected.
Another question from Dr. Adalto Mediciano. This question of nullifying the administrative act in terms of what has been determined by the Brazilian PTO, if the law is not clear on that, would it be appropriate to assess it in terms of the right of precedence? As I said, only if this issue has already been raised in terms of the opposition administratively. Otherwise, no. Not even in that intermediary space in terms of the time frame, right? No. In that decision of Judge Liliane Horiz reached a few years ago. Yeah, that position is interesting. It's an intermediary position, but in principle, no. Only in case of opposition. There's another question from Aline Ferreira de Carvalho da Silva, and it goes to Henrique. Precedence versus nullifying administratively. If the law is not clear and considering the precedent by the user, and since we are talking of claims under the Brazilian PTO, could that be seen in terms of an administrative nullifying process? And Enrique, could you talk about the trademarks of the drug dealer narco?
Yeah, I can talk about the drug dealer, the narco trademarks, but only because he's in jail. Otherwise, I would not talk about that. I'm going to go first to that. What happened is that there were a series of trademarks. Everybody knows El Chapo. El Chapo is a very well-known drug dealer that is currently being held in jail in New York, and he was convicted. They apply for a trademark El Chapo, and they apply for other trademarks El Chapo Guzman. In all the cases, they were first denied by the Mexican Patent and Trademark Office, and the reason why they were denied is because the authority considered that they were against the good customs and the moral and the ethic and and they were itself despicable. Some of them, all the decisions were appealed, and some of them were reverted and the court ordered to grant them because they considered that itself El Chapo was an acronym used for a person, and in spite that his activities were illegal, the acronym itself was not illegal and had no negative connotation, even that the authority could see that, it was a negative impact to have clothing called El Chapo or Chapo Guzman. they decided to grant them. Some of the trademarks, like El Chapo Guzman and not just El Chapo, they were denied because they were not applied directly by him. They were applied by another person. So since it included the acronym plus, or the acronym plus the last name, so that was the reason why they were denied. But some of them, they were even registered depending of the products. Here in this particular situation, had to do with what Pedro said. In some cases, they considered that they had to be rejected because the products they were going to be protected were illegal, or the direct connotation was incorrect. But at the end, what is very important is they never apply for El Chapo for marijuana. So the question is, can that be registered or not? If he was known because of a drug dealer and a general drug dealer that started with marijuana, then with cocaine and everything, if the product had nothing to do with his illegal activities, should they or should not be registered? In my opinion, they should be registered.
A question from Dr. Melo. I would like to hear from Dr. Marcia if you have any comments on the Mexican decisions. The question comes from Suyan Casiano de Melo. I would like to hear the views of Dr. Marcia, whether she has any comments on the Mexican cases, any parallel to be established with the Brazil. I think these Brazilian considerations, the Brazilian perspective has already been presented. I think it's precisely what you summarized after he talked. These are very distinct cases. There's still one question.
And Ricardo, I would like to jump because I would like to ask a question to Marcia, because everybody had examples considering sex and sex toys. So I also have my personal example, and I would like to see the position of Marcia as a judge. In Mexico, everybody knows the trademark Hustler. Hustler was a very well known publication in the United States mostly that has to do with magazines. It was the direct competitor of Playboy. So in Mexico, it was very interesting because the Mexican Patent and Trademark Office decided to grant the trademark Hustler in connection to magazines. However, it decided to reject and to deny the registration of the trademark Hustler in connection to sex toys. So from your standpoint, Marcia, and consider what we have discussed, is that correct or incorrect? Considering the Brazilian precedents on how you dealt with this?
If it was under my responsibility without prejudging, I think this is an extreme moralistic position. It is an industry, a very vast industry, in fact, and as all the others, this sector has the right to have trademarks and patents like any other. So I don't see any problem in terms of giving industrial property rights to this sector. I don't see any problem. I believe this is a misconception emerging from centuries of religious education. But sexuality is a part of our life, and therefore I think it would not be right to not to grant such right on grounds of immorality and trademarks should be granted to sex toys and sex shops. This is my view.
Well, I love the response, and probably I apologize for my Brazilian colleagues because I may be moving to Brazil. I like the way of your thinking. I fully agree with you.
Pedro, there's still one question. What are the means of evidence accepted by the Brazilian PTO, and these means of evidence, do they all have to have dates? Well, I apologize, but I'm going to refer to the trademark manual again. It's not exhaustive, but there are many examples. We can never neglect the documentation, but yes, we have to have dates, and there's a whole list that goes from invoices, nothing that is not the ordinary, what is expected. I can't give you the exact list. I can just refer you to the manual. All the evidence means that are admitted in the law. And of course, it is important to have the date. As you said, it's not exhaustive. It's just, these are just examples. I'm being told that we have reached the time frame that had been given to us. There are other questions, but unfortunately, we will have to conclude. And Marcia, once again, thank you. Thank you for your willingness. You, Mr. Alvisi, and for explaining the position of the Brazilian PTO, and Henrique, thank you. Your presentation was very clear, and you said something very important that I'm going to repeat. Many of the controversial trade-related issues that are they are contributing to the backlog. You have been able to include it in the law. And I can say that given the many conversations that I've had with Dr. Andrea, who is the trademark director, anything that can be done to improve the trademark system will be done. We have here, as I said previously, many topics deserve discussing. Agreement of coexistence, secondary meaning, the colors that can be applied to packaging, holograms, are they protected? And the list goes on and on in terms of other controversial issues that we would like to discuss. Unfortunately, our time, 1 hour and a half, is not enough to explore as much as we would like. Thank you. And I would like to thank ABPI and all of you, not only the panel members, but also the audience. And I know that the audience was very significant. Thank you and good afternoon.
Good afternoon. Thank you very much.
Faz algum tempo que falamos da velocidade das transformações do mundo. Mas, na verdade, esperávamos que essas mudanças seguissem um ritmo imposto por nós mesmos, segundo nossas próprias necessidades. Como se as mudanças fossem previsíveis ou fáceis de assimilar. Até que o mundo parou. E tivemos que ouvir as notícias e ver de frente a nossa própria vulnerabilidade. Nenhum de nós esperava experimentar uma situação como esta. Mas aqui estamos, imersos nela. Mas será que conseguimos aprender alguma coisa com
Have we been able to learn
Ser capaz de
anything with all
aprender
that?
é a marca
Being
maior
able
da
to
nossa condição
learn
humana.
is the
Mas
trademark
tivemos
of
que
human
nos
condition.
superar para lidar com o que
We
chegou.
had
E
to
agora
overcome
ficou
ourselves
patente
and our
o que é
difficulties to be able
verdadeiramente
to handle
importante
what
para
we
nós.
have at stake. And now it's very
Entendemos
clear
que fazemos
what is
parte de um
important to us.
grande
We
ecossistema
understand
e
that
que
we are part
cada
of a
um
very large
depende dos
ecosystem
demais. O
and that
desafio é
each one
aprender juntos os
depend
novos
on the
caminhos
other.
da
The challenge
transformação
is to
digital.
learn together
Fazer
the
diferença com
roads
inovação,
of digital
empatia
transformation,
e
bring about
coragem. É com esse
difference
espírito
with
que a equipe
innovation,
da
empathy,
LB
and
Soft
courage.
está
And
aqui
this is
pronta
the
para ajudar
spirit
você a
of
fazer cada
LB
vez mais
Soft.
pelo
That's
seu
how we
cliente,
plan to
oferecendo
help you
meios para você
to
trabalhar com
support your
mais
client,
produtividade
offering
e
means so that you
eficiência,
can be more
mesmo nas
productive and more
condições
efficient,
inesperadas do trabalho
even in
totalmente
the
remoto.
unexpected
Nossas ferramentas
conditions of
oferecem
totally
aquilo que
remote
você
work.
precisa
Our
para dar
tools
atenção a
offer you
tudo
what
que
you
realmente
need
importa e que só
to pay
você pode
attention to
fazer.
everything that
Assim,
matters
ter
and
tempo
that
para
only
oferecer ao
you
seu
can
cliente
do.
os
And
resultados
so,
de
have
excelência que
time
ele
to
sabe que
offer
vai
your
receber de você.
customers and
Por
clients
isso, vamos continuar
results of
firmes
quality
para
which
que
are
em
expected
breve
from you.
possamos
So let's
destampar
keep
nossos
going
sorrisos
firmly
e
so that very
comemorarmos as
soon we can
novas
unveil our
conquistas
smiles
juntos nos
and
desafios
commemorate
que estão
our
por vir.
accomplishment
LB Soft,
together as well as
potencializando o
the
universo
challenges
jurídico através da
ahead.
tecnologia.
So LD Soft, potentializing law through technology.